Good afternoon, everyone, and welcome to your weekly Wednesday webinar with the Property Law Alliance. As always, it's good to be back with you guys. It's been a jam-packed week, but we've got three of our experts here today to answer your questions that you posed to us during the week and in last week's seminar as well. So as always, lovely to have you with us, Silna. How are you doing?
I'm very good, thank you. In the middle of load shedding, hence the slight delay and my medium sweaty. Oh my goodness, I can't get us live on Facebook, look, because we're making things work currently with a fish tank light above me for light and amazing inverters and stuff. So I'm just grateful to be here in the middle of load shedding. No weather talk from me tonight.
None at all. Yeah, it's all about load shedding right now.
Load shedding.
Bruno, how are you doing? I think Bruno's on mute there. We're gonna.
We are technologically amazing tonight, guys.
I haven't made that mistake in months, I have to admit. Like I thought
I don't think you ever did. I don't think you've ever done that.
We'll blame it on load shedding. Bruno, how are you?
I'm well, thank you. Had one hell of a day, but I'm doing well.
No, that's good to hear, man. And Greg, it's so good to have you with us. First time this year. How are you doing?
Thanks, Chris. Yeah, fine. Sorry, man. It's inordinately early in my day, I'm afraid, so I can't always make it. But I thought, no, today I can't miss another one. So here I am. Thank you, and Chris, nice to meet you formally.
You as well. It's good to have you with us. I must tell you guys a quick story about what Bruno just did now, muting his mic. Today I was in a meeting and I had my camera muted, off, and I thought it was off. I thought I'd put it off, and I actually didn't. And I stood up. So I wear a shirt, but I've got shorts on. And here I am standing up with my shorts, and there's about 10 people in this meeting looking at me in the shortest shorts I have. So Bruno, don't feel bad about your blunder. It happens to all of us.
It could have been much worse. I think we've all seen the worst ones, and I think we've all seen today that video that's going around with the lawyer in Texas with the little cat. That's very cute.
A big improvement all around, except for you, still now.
Okay, guys. So we've got quite a jam-packed session today. I'm going to get into the first question, which was asked by Miss Lisa van der Merwe. She's very frustrated with the law, if I can put it that way. And she says basically the law is not on our side. And when she says our side, she's talking about landlords. She says that she followed the eviction process since last year, June, to evict a tenant of hers. She said she followed every procedure that was, available to her and lawfully so. And the tenant refused to pay rent. She then goes into court and during the eviction proceedings, the judge favored the tenant by giving him up until April 2021 to be evicted or to be on the property. She asks, where is the justice in this? Because she's sitting now without almost a year without rent. The lease has been terminated. The tenant, she says, is destroying her property. There's disturbance letters being sent back and forth from the body corporate. And she wants to know, where is the justice for landlords? So I'm gonna throw this one to you, Greg. Where is the justice for landlords in this?
There's none. In a summary, that is an inordinately long time. Look, we've all been in this fight for years now. The courts are very cautious about evictions. They are very anxious to avoid causing an injustice to the occupier. Many courts seem to take the line that, well, you're lucky enough I'm considering your property rights at all. You are the owner, therefore structurally you are in a better position than the person facing eviction. That's often true, but it's not always true. I mean, not all owners are massive evil corporates, or even good corporates. They are simply people who require the rent to pay their bills, to live on sometimes, to pay their bond. I had an interesting instance when a friend of mine, or one of my colleagues, started in the firm, and with a sort of long history of human rights work at university, and we had a long debate: can you do this job? And we eventually decided, well, yes, I can. The very first matter that came in was an elderly woman with an adult disabled son who lived and provided for her disabled child on the rent she received from a cottage. The guy stopped paying rent. So suddenly now the moral equivalence of the whole thing was different from what you might expect in contemplating a human rights outcome. So as a result of which, she jumped into this job and has done it very effectively ever since, because she realized on her first day that it's not what they say in property law at Wits, for example. Not all ownership is evil, not all landlords are bad. Sometimes the tenant is bad. Now, all of this is just by way of context, because the courts, especially over the pandemic, have been very, very cautious. They're cautious anyway, but now they've been exceptionally cautious, and we've all seen some quite unusual orders. My own view on this matter is the only justification for this long time would be a very narrow set of circumstances, because normally it's binary. Is there a danger of homelessness? If there is, the council must be ordered to provide temporary emergency accommodation for that individual. If there isn't a danger of homelessness, then why wait 6, 8, 10 months before the person can be evicted? It doesn't make sense to me. The only potential circumstance is if, in the facts of this case, and I'm sure this isn't the case, the guy said, I have a new job starting on date X. It will definitely happen by date Y. I can pay rental. That's the only circumstance I can imagine where it is justified to have given that length of time. Otherwise, it can't be fair. It's not fair to the owner. We on this side of the equation, being landlords, landlord attorneys, are aware of that sort of moral equivalence that I talked about earlier on, where it's not always easy. Even though a big corporate, a well-resourced corporate, why should it wait months and months and months for an eviction? It's not right. It's not fair. But it does sound unusual as well.
No, exactly. Thanks for that, Greg. I'm going to just open it up now quickly to Silna. What's your thoughts on this one, Silna?
Yes, so it's really a very interesting one. I must say, I've seen weird orders. Oh my goodness, I think the power's back. Yay! Thank you. So the thing is, I think I've seen weird orders. I've seen orders where the court gave a long time period to vacate. But there's usually some of the other reason for that, like Greg mentioned, like someone that says, I would be able to pay rent then. Or the only other option I can see is if the eviction was done in terms of buy and the occupant was in illegal occupation for a period exceeding 6 months, then the judge might have took an angle that the owner now has an obligation to provide alternative accommodation for this person for a certain time period, and someone uses the property that they are in as the alternative accommodation. But as Greg rightly said, the only time a court will be forced to make a decision like that is if the person will be left homeless and destitute. Mm-hmm. And the owner of the property didn't take action and didn't commence eviction for a very long time period. Now, in that case, we have to consider the court is going to look at this and say, okay, this person's been in illegal occupation for more than 6 months. Remember, guys, when I say illegal occupation, I do not mean a tenant that hasn't been paying rent for 6 months. I mean cancellation of the lease agreement for more than 6 months and you haven't done anything. Or you purchased the property on an auction and you haven't done anything for 6 months. That's the 6 months that I'm talking about, not a tenant hasn't been paying and you haven't taken action or something. Illegal occupation. The court's going to say why did we leave this person for 6 months? Why are you now suddenly wanting an order for them to vacate this quick, but it took you this long to commence your proceedings? And I would have liked to see exactly what Greg said about bringing the owner's position in front of the court to get an order that would be just and equitable. So you guys know I always throw in Ubuntu, and usually when we talk about Ubuntu in evictions, it's in an answering affidavit where the respondent is saying, oh, let's just look at my story. When I talk about Ubuntu in evictions, I talk about both party stories. Exactly the story that you told, Craig, about your client who needed that money, the rental income, to support her disabled child. If the attorney is not pleading and not telling the court the story that the owner is in, then you might end up with orders like that. And it brings me back to the conversation we always have. When you go to a firm to do an eviction, you need to know that they're going to look at every angle of your matter and bring it before a court in a way that the court will consider your position as well. So I know talking about Ubuntu and evictions on behalf of the landlord is always a weird thing. But I really think that's the angle that we should take. If a court only sees you as the landlord, the one with the deeper pockets, the one with the lesser problems, if the court doesn't know that you are reliant on this rental income to support whatever or whoever, whatever your story is, the court has to hear your story to be able to make an order that is just and equitable. So I hear what we're saying, and very often it does feel like the landlord doesn't have any rights or isn't treated fairly. In this particular case, out of context, I can see that it would look like that. But for me to make a call on that, I'm going to have to see the full facts of the matter. And the truth is, if you plead correctly, and if you use the law in the way it's intended to be used, a landlord can be in a strong position. You just need to apply the rights correctly. That is amazing, Greg. You just...
Yeah, that's an amazing change of background.
It was amazing.
I tried to get the cat on. I tried to, sorry, guys.
That was beautiful. I'm done.
My phone died. I had to find a charger.
No, thanks for that, Solna. I want to ask Bruno a question here. So this person has been in occupation of the property and in illegal occupation of the property for an extended duration of time. Would it be a case that the landlord here could perhaps claim occupational rental? This person is there. How would that work? How would we look at that? Is there a claim for that? Is there not? Because an order was granted and the judge said, well, you're here until April 2021. Can there be a claim of that nature?
So I suppose it goes back to something that Solna said. We'd have to look at the case just to see what's been happening here, because the reality is, if this was a tenant that was there by virtue of a lease agreement, and for some reason they haven't been paying rent, they weren't breached, the lease agreement was cancelled, or everything was done correctly, eviction application instituted, and the court made an order to this extreme, I would probably suspect that the chances of actually being able to collect any form of rent in the form of damages, so it's not rent strictly speaking, because that's a contractual term, but it's holding over damages, which is basically the equivalent of what rent would be. But the prospect of actually being able to collect something like that would be slim. So off the bat, just on the facts that you've given me, it's a crazy period of time, honestly, from my experience, because it's really, really long. I've had some really weird evictions, and even on those evictions, I've never been asked to wait. What's this, about 10 months, 9 months, somewhere around there? You said from June to April. That's really unheard of, especially if it's tenant based. If it's tenant based, I can tell you right now, I've never had to deal with something like that, because with tenant based, there's normally an amount of rent that's supposed to be paid in terms of a contract, and one would reasonably expect is that the person would be able to get a job, acquire, be able to pay that amount of rent somewhere else. With the sale and execution experience that I've had, I have seen really crazy scenarios where, it was a person's home, and unfortunately, they don't have anywhere else to move, but still 8 months is quite long. So to be able to recover damages in these circumstances, it's doubtful, because if it got this bad to begin with, what would you actually be able to recover, to be fair?
But you can get, sorry.
Sorry,
And
Fiona?
you might be able to get you might be able to get an order for it, like a damages claim order. But I mean, it's a very easy defense to say, there's a court order allowing me to stay here, and the court made no any money that has to be paid. So even if you...
It can't be a defense.
But I mean, what I'm saying is, even if you get the order, the prospects of getting is slim. And the point I'm trying to make is, somebody's going to plead that, because remember, we see defenses that you're like, really? Did you think that defense is going to fly? You see funny things, but that's going to delay, and it's going to end up costing the owner even more money to get to an order, and then to go back to your client and say, sorry, we can't collect on this. I don't know if it's wise to throw good money after bad.
No, but if you've been given an order executable 8 months in advance, and you are losing 8 months worth of rental, you have a lot of bad money that you have to take into account. And in which case, I mean, a court order doesn't allow someone to stay there; it just suspends the eviction for a period of time. It's not a defense. It can never be a defense. I'll be laughed out of court with that one. So what I would do is a rent interdict summons is cheap, or maybe even a damages summons with the holding over, and do that and take their stuff. Don't allow them to sit there thumbing their nose at you for 8 months, even though they might not have valuable stuff, even though they might not have money. Take it, or at least put the fear of it going in them, because they might wake up and go. So at the cost, I don't know what the rental is. Let's say it's a small rent. Let's say it's $5,000 a month. That's still 40 grand that you're going to lose over this time, and not gain by having a decent tenant. So I don't know. I mean, I do know it will definitely, in terms of recovery, probably not going to recover. That's not the whole story. Hit them with a summons, take their stuff, remove it, sell it in execution. If they want to be so, stay in your property with no rent for 8 months, and must feel the consequences. And that's expensive.
Okay.
Yeah, that's fair. My only concern would still be the legal cost on top of that. So the point I'm trying to make is, I hear what you're saying, Rick, but at the same time, I wouldn't want to put a client in a position where they think spending money is going to get money back. That's the point I'm trying to say. You're not going to, yes, let's make life a bit more difficult, but do you have the money? Does the owner have the money to spend to make their lives slightly more difficult? Because the truth is, I've seen evictions where we remove items in execution, and then the people say, well, because I didn't have a heater anymore, I've made a fire in the middle of my living room. People get weird. So I think the answer to this would then be, it depends on the circumstances, the specific circumstances, because in many cases, I would advise my clients strongly against pursuing the damage claim. See, now I'm used to the boxing matches now, and now I'm just arguing with Greg now.
So the reality is we've seen it both ways, and it does come down to that. Selma pointed it out correctly now. So what Greg is saying is, the reality, if you're under that pressure, the tenant or occupier is on the property for that long and you've got nothing else to lose, it's not a bad idea to do it. I've also had experiences where that works. And it is almost a risk management component to this whole thing, with a psychological aspect of trying to figure out what reaction you're going to get. You are, to a certain degree, it does it does resemble certain elements of chess, where if you make the right move, you might get a result that's best for your client, or it might completely mess everything up. I've had cases, for example, where we continuously removed, and every 2 months the sheriff went there, removed, there was an interpleader. Sheriff went, removed, interpleader, and the client was not happy with the fact that every time we did something, it was obstruction, and the person didn't mind staying there. They quickly replenished, and then every month they used to get rid of the expensive things they had there. On the other hand, I've had cases where it did work. The people thought, haha, you'll never kick me out because the court gave an order 3-4 months down the line, and then you go there with a judgment and a warrant saying, well, yes, but you've been staying on the property for 6 months. The court has ordered that you pay rent for the last whatever 6 months, and we're removing this. And all of a sudden people wake up and they realize that not being evicted does not mean that you don't have to account or be held responsible for what you're doing wrong, or the occupation that you're enjoying. So yeah, it is both ways. So as far as this lady is concerned, honestly, where's the justice? The court system does provide for certain remedies, certain recourse. The problem is your case is in one extreme where, unfortunately, as Greg pointed out, I'm sorry, I can't see where that's reasonable, and I do feel on the face of it that it's unfair. I don't know what's actually happened on the papers, but for the most part, I've never actually experienced something to that extreme in tenanted situations, at the very least. Maybe with more complex evictions, but that's almost come to be expected. But with tenanted ones, I highly doubt it. I haven't seen it.
No, thanks.
Sorry, Chris.
Go ahead, Dave.
Chasing arrears is never a good. I mean, it's a waste of money. The last thing people don't pay is their rent. There really is little chance, little reason to spend money to chase arrears, and certainly that's my normal position. My normal position is, if an unopposed eviction is going to take 3, maybe 4 months to get done, there's no point in spending that money to issue a summons, etc., etc. But my point was in these unusual circumstances where you have an 8-month plus delay, that you have an 8-month plus delay, what it's going to cost you in lost rental, etc., etc. So in those circumstances and those alone, I would say find a few more grand, make it miserable. Get the municipality to turn off the services. Do everything you need to do. You've got the certainty of your lost rental till April. So in that context, look for a plan B, but only then. I mean, I would obviously agree with you on that.
Thanks, guys, for that. That's such a wealth and rich, the depth of information that we just got from the three of you there is remarkable. I would advise Lisa, if you're watching this, or if anybody else is having a similar situation to this or has experienced something similar, to contact our experts here, to contact the Property Law Alliance as well, and to get your questions asked and answered. I'm going to move on quickly to the next question, which is a very interesting question. It was posed by a lady by the name of Johanna Jamar, and she asked the question on behalf of her fiancé. She notes that her fiancé and her mother-in-law own a house, and they each hold a 50% stake in this property. She says a year ago, her mother-in-law drew up a will, and she included her fiancé in this will to inherit her mother-in-law's 50% stake in that property. 2 months ago, she then discovers that her fiancé was removed from the will, and that a granddaughter would instead inherit her mother-in-law's 50% stake in the property. A question then is, can her mother-in-law do this? And is it possible for there to be two owners of the property in this particular instance? So is it possible? Silna, I'm going to throw this one your way. What's your views on this?
Yes, so Chris, already the question started, I'm correct in saying the fiancé and the mother-in-law are co-owners already as it is, right?
Yes, that's 100% true, yeah.
So the beauty of the question, the answer to the second part of the question lies in the question itself. They are already co-owning the property. So property is co-owned is you have an undivided share in the property. That means, let's quickly take shareholding, for instance, in a company. You have divided shares. This is my shares, you have, call it 9,000 shares, and it's divided in a specific way. Shares isn't, let's just quickly say, a thing. It's not a real thing. It's not a tangible thing. So whether I have this share and you have that share, nobody really cares. As long there's a certain value attached to a thing, and you multiply it with how many of that thing you own. The shareholding works like that in a company. If we look at a property can only be held, immovable property can only be held in undivided shares. So what that means is I can't own this room and the room next door, but the living room belongs to someone else. You know, it doesn't work like that. It's an undivided share. And there's another cat again in the show. Everyone needs whiskey. It's very good. So undivided shareholding means that the property is owned and there's no limit to the amount of people that can own a property together. So definitely at this stage, him, the fiancé, and the mother-in-law owns the property in 50-50 or whatever other shareholding, undivided shares. A person has a right to bequeath their estate in whichever way they deem fit. To make it better, you can change your mind. You can change your mind and change your will for as long as you are compos mentis, so completely, help me, Bruno, with a translation, please.
Of sound mind?
Sound mind, that's the word I'm looking for. Thank you. So as long as you're of sound mind, you're allowed to change your will. You need to stick to the rules. There are very specific ways of, like, for instance, you're not allowed to sign too far from the last, writing in the will, kid versus the master, things like that. You never forget that. It's important to know that. But if she was of sound mind, is currently of sound mind, or at least was at the time of the execution of the will, so when they signed it, if the will was executed correctly, so 2 witnesses present at the time of signature, signed within the limitations of the law, she's definitely allowed to bequeath that property to absolutely anybody. However, because this is why we practice law, not for the rules, for the exceptions. Everybody knows the rules, lawyers knows the exceptions. So the exception to this rule would be, if they had an agreement, even a verbal agreement, where they said, we're going to buy the property together, and when I pass away, you're going to get the property. Then there's a whole lot of other things that's going to happen. My advice would be, sort this out while the mother-in-law is still alive. Because once you have to go and litigate about what somebody's intentions were after they've passed on, that kite's not going to fly. And this is why the law of succession is one of the funner fields of the law to read case law in, because you always think, kids, this is so dramatic afterwards, because now people are claiming that they had agreements with someone that's now dead. So you can't prove it. How do you prove that what somebody said when they are dead? The answer is easy, you can't. You can't prove that. So my suggestion is sort it out now and make sure the family agrees to everything while everybody is still alive. People don't like talking about deaths. People don't like talking about wills. This is the reason families don't spend Christmas together. Talk about it while everybody is still alive and well, but the person who owns the property has the full right to bequeath it to whoever they see fit.
Thanks, Selma. Bruno, do you want to add a little bit of an opinion to this, or maybe around a question that I was thinking about in terms of, if the mother was pressurized, if let's say, for instance, the granddaughter influenced the grandmother in some way when the grandmother was not of sound mind. Let's say, for instance, the grandmother has periods or intervals of sound mind and then periods where she isn't. And during a period where she wasn't of sound mind, the granddaughter comes in and influences her. So when she is of sound mind, she just quickly makes draws up another will. Bruno, what would be your opinion on that? And I think we can maybe then throw that situation back to Solna again.
So if a person was coerced into bequeathing something in terms of a will by some level of force, then you can invalidate that will relatively easily. Similarly, if a person is not of sound mind when actually signing off the will or expressing the instructions, also can be invalidated. The problem that we tend to experience in those type of situations is proving it after the fact, because once the person has passed away, to try then and go, well, they were coerced, how can you prove that? So the circumstances would have to be so apparent that it's clear as day that it actually did happen. Being of unsound mind, that might be a little bit easier, because I mean, with medical reports, one could actually look at a certain period of time, for instance, when everyone knew that was the case, when their estate was being taken care of by their children, and all of a sudden a will was signed somewhere in the middle of this chaos. That might be a little bit easier to prove, but it's not always that simple. Sometimes these wills are signed right towards the end, or not even towards the end, right towards the point where it becomes apparent. And just before that, it's very difficult to prove whether a person was forced into it or not. So look, with respect to this, the one very interesting thing, and this applies both in the cases of divorce and in the cases of death, succession, is there's a lot of confusion when it comes to actual commercial transactions and things like joint ownership, and that people don't often equate and don't think about. The reality with joint ownership and why people enter into certain transactions, what are the terms of those transactions? Many people go off and they buy properties together. And when it comes down to it, it's because remember, no one wants to buy a half share either. So when actually dealing with properties like this, it also becomes, because no one wants to be a owner of an undivided half share of a property. It's there's so little you can do with it. You can't sell it for proper value because there's somebody else in there. No decisions can be made. It's very difficult. So more often than not, and I've had cases like this where you can imply, there's a tacit term that a person that we can look at and say the property was bought under these circumstances and should be dealt with, where the parties believe that this is how it was going to be dealt with. But unless you have it in writing, it's very difficult to prove. So if now people are aware of this and there's still time to actually dispute this, I would probably go forth and try and set out the parameters of this arrangement so that we know exactly how this property is supposed to be dealt with, how this half share is supposed to be dealt with. If there is a commercial agreement that even if the half owner wants to leave it to somebody else, there might be a commercial arrangement where it still gets transferred and value gets shifted and that person benefits from it, if that is the case. But yeah, it's unfortunately, if I think it was the mother-in-law, if she leaves, she's entitled to leave it to whoever she desires. So you can't stop her from doing that. It just makes life very, very difficult.
Okay, thanks for that, Bruno. I think then we will move on to the next question, which was posed by Gloria Modau. And her question is around an eviction. And what she wants to know is, what is the way around an eviction in a situation where a general worker was given consent to stay on a property, this particular property being a TVET college, and that worker was given permission to stay there for a temporary basis. There was no lease agreement concluded, there was no rent agreed upon, and no rental was, of course, paid in the situation. The consent was granted by an individual who was previously in charge of the property, that being the principal of the TVET college. She says that there is now a new principal or person in charge who is demanding that this this general worker now vacate the property. I'm going to throw this one quickly to Bruno. Bruno, what's your view on this?
So I actually dealt with a very similar case a couple of years back. And in cases like this, there's this overlap between eviction law and labor law, which does sometimes complicate things. So maybe just from the outset, occupation like this is still considered to be a proper occupation. So there's consent, and the person occupying the property received that consent. So they technically were at some point or another lawfully in occupation, right? If that's the fact that we're given. So we must bear this in mind. And by virtue of this, our typical eviction laws would apply on how to deal with this. If it was agricultural land, it's a different story. But because over here we're dealing with a TVET college, but occupation by virtue of employment, the provisions of PI should apply to this. The problem now is, in addition to the provisions of PI, you're also looking at now labor relations and the basic conditions of employment and. And the problem that I experienced in my specific case was occupation was part and parcel of the job. So with us, it was caretakers occupying buildings, and they got free occupation. So they weren't expect of free occupation. That's very loose. So they got occupation in exchange for which they had certain roles and responsibilities that they had to fulfill. So one would first have to deal with the employment contract, determine whether that was still in place or not. And once that determination was made, and you can clearly say that occupation was terminated by virtue of the termination of employment contract, for example, then you could proceed with your eviction. So we almost had to work on it in levels, because the employment contract was being disputed and the dismissal was being disputed, and the courts felt very uneasy giving an order until they knew for certain whether there was an unfair dismissal or not. So in a case like this, for instance, the problem is it's not very clear, but what were the terms of the occupation? Was it in any way tied to the job? If it was tied to the job, how can you now all of a sudden unilaterally take that away from someone? Because this is a benefit or a form of remuneration. So you can't simply take it away, because that goes against your labor law, unless the occupation had nothing to do with the job and was two separate things. But one would need to define this. And if it is two separate things not tied to each other, yes, you can proceed with the eviction. If they tied together by virtue of the employment contract, you need to deal with the employment contract and then deal with the eviction. Or at least that's my experience.
Okay, I'm gonna pass this also on to Solna to give your opinion, and if you have one for us quickly.
I have an opinion. I am more curious about Greg's. I've never heard Greg say anything about labor law. Now, I have a very good idea how I feel about labor law, but this is going to be too entertaining for me not to hear Greg's opinion. Greg, please educate us.
Labor law is like jazz. It's not real law. It's like jazz is not real music. You make it up as you go along. That's all.
See, I knew it's going to be gold.
You have just pissed off a lot of labor attorneys, Greg.
Sorry.
Well,
this picture behind me was given me by one of my best friends who's a labor lawyer. But you might as well have been a jazz musician.
Well, you can have an amazingly fun bra on Saturday. No, I think we share a sentiment between eviction lawyers when it comes to labor, because we see a very, very different part of the law. I'm personally also not really a fan of labor law, and that's exactly it. If this person, I don't even know when it's fair to fire someone or not. I feel if somebody doesn't contribute to your team, it's fair to fire them. But I think in this particular case, Bruno, I can just echo what you said. If the dismissal was done properly and in terms of the particular part of the law, then obviously the person derived his right of occupation from his employment. And when his employment's then terminated, his right to occupy is terminated. Similar to a lease agreement, if you don't pay your rent, place you on terms, cancel the agreement, you derived your right from that document. If it's out of the way, it's out of the way. If you derive your right of occupation from your labor relationship, and that's gone, then it's then unfortunately, if the person doesn't vacate, they can be evicted, and then you're more than willing to take those employees off the hands of the labor lawyers.
It was
Thanks,
actually such a strange matter because I don't do labor law. I know I've done it when I articled. I know like some of my commercial clients have approached me for labor advice. We normally like brief counsel to assist us. And in this case, the problem is you couldn't have two different sets of attorneys because they were like it was intrinsically linked. So you had to have the same team trying to deal with it. And here you had like eviction attorneys trying to figure out like their way around labor court and the rules of labor court, which are very different. And yeah,
CCMA, like
and
what?
CCMA, yeah, because this thing went up to labor court on review. So we had to do CCMA appearances, and then all of a sudden there's a review, and you're like, what? Why? How does this work? And then you go there, and they've got different condemnation rules, and they're a lot stricter. Yeah, sure. Like I
It's
don't know
jazz.
how we went through that.
Yeah. So Greg, I have a question for you. If labor law is jazz, what is property law?
Punk rock. Punk rock, man. The Clash and the Sex Pistols wrapped into one. No, only joking. I don't really mean that. I sort of do about jazz, less so about labor law.
Yeah, because I wanted to say I do enjoy good jazz, you know, on a Friday evening with a glass of wine. If the weather, you know, allows for it, I can definitely handle some jazz.
People like jazz. Not my fault.
Exactly. But see, now I had to admit to my one shortcoming of enjoying.
That's all right. There was wine involved.
Okay, guys. So that brings us to the end of the questions that we had posed to us for this Wednesday. I just wanted to thank you, all three of you, for your time and for the differing opinions that you have as well. And like I said earlier, it's a wealth of knowledge that we have here. So if you have a question, for the viewers watching this, if you have a question that you want to pose, please go through to the Property Law Alliance group, post your question there. We will be in touch with you, and hopefully we'll get to answer your question on a Wednesday, and that being next week. So tune in for next week's session. And yeah, I hope that you all have a great week. Thank you, Silna, as always. Thank you, Bruno. Thank you, Greg. And we'll see you guys next week.
Cool. Thanks, Chris.
Thanks, guys. Bye.
Bye.